Hi, welcome everyone. My name is Rilus Dana, and today we're talking probate, one of my favorite topics. So, we're going to be talking about how long it takes to probate a will and what to do if there is no will. So, let me share my screen here. All right, so let's get into it. So, this is where I practice law in Arizona and California. Dana and Associates, got our phone number, website there. If you need help with probate or estate planning in Arizona and California, we can help you out. All right, so let's go over some of the steps and lay a little groundwork before we get into probate. So, after someone's passed away, the way that you assess the situation, what I like to look at first are what are the assets? What's in the estate? Does the person have retirement accounts, life insurance, bank accounts, real estate? How do you find those things? So ideally, there'll be some records left for you, so it's really easy. That's not always the case though. So you might have to search for clues, meaning look around their house for bank statements, or you can start getting their mail to see what comes in the mail. Or maybe you have some access to some of their digital records to see what they owned. But you need to determine what a person owned in order to evaluate the estate. Let's define the players. So we have the decedent, that's the dead person. So another word for the dead person is decedent. Fiduciary, that's who's going to be in charge of managing the estate. Beneficiary, who gets the stuff. Be multiple beneficiaries. All right, what is an estate? Is it a large house? Sometimes that's used to describe a large house, but in this context, we mean everything a person owned, whether alive or dead. So in this case, usually when they're dead at this point. So an estate is everything that is in the name of the deceased person, the decedent. Fiduciary is a person to whom property or power is entrusted for the benefit of another. I use this little green bookkeeper visor to represent the fiduciary. Now, fiduciary duty, when you're wearing this visor, that means they have a legal obligation to act in the best interest of another party. All right, what if there's no will? So, how do you figure out where things go if there's no will? So, intestate is what that's called. That means there's no will. So, Uncle Sam's got you covered. So, look up the laws. So, the laws in that state to determine who has the priority to serve as the personal representative and who the beneficiaries will be. If there's no family members, we get this call a lot. Well, what if there really is no family? If there really is no family, it's going to go to the state. So look all the way to like second cousins and see if you can locate a family member. I don't care how good a friend you are or what the relationship is. If it's not a legal one, boyfriend, girlfriend, that is not a legal relationship. So it's going to go to the family members. The last will and testament is a document where you designate who the beneficiaries of your estate will be, guardian of minor children, and who the personal representative of your estate will be. Now, it takes a probate in order to activate those powers, to activate the power of the personal representative and also the guardian. Okay, so probate, what is probate? It's the judicial process where the courts legally authenticate a last will and testament, or they determine the heirs, and they appoint a personal representative to manage the estate. Here's a scenario here. This couple owned a house. She had a bank account in her name and some life insurance. She passed away. The life insurance named him as the beneficiary so that he was able to collect that without probate. His house or his name was on the house as an owner of the house, so he collects that without probate. But how does he collect this bank account still in the name of his deceased wife? So we locate her will, determine who's listed as a personal representative, it's him. Determine who the beneficiary is, also him, Mr. Estate, the surviving spouse. But it's got to go through probate to activate that power. It's got to prove um, that he can act for the estate. So the first steps in the probate is he's going to be appointed as the personal representative. So that's when he has the authority to sell real estate if there is any, to collect bank accounts. That's when people will actually talk to him regarding the estate. Now, there's a bunch of steps that need to be done after he's appointed as the personal representative. So, how long does this take? Let's take a look at it. So, how long the entire process take once he's appointed until the time that we close the probate? But here's what we're looking at. So, the first thing is once you hire an attorney. So once we get hired to do a probate, it takes us about 2 to 3 weeks to prepare. We call it the first wave of paperwork. There's an application for the probate and some other things that go along with that. So the client needs to sign those, all those documents, and then we'll file it with the court. It'll take the court anywhere from 2 to 6 weeks to approve that application and appoint a personal representative. So already we're looking at about 4 to maybe as long as 8 weeks for those steps. Now, after the court appoints the personal representative, the next step is to publish in the newspaper and start the creditor period. So this is required to give all potential creditors notice, and you have to wait 4 months for them to make a claim against the estate. So even if we go really fast and get everything filed with the court right away and they approve it right away, we still have to wait 4 months for that creditor period. Now, during that time, you'll also notify any known creditors. In addition to publishing in the newspaper, you have to notify any creditors that you know about. And then that's the time to collect all the assets. So if there's real estate, it can be sold. There's stocks, lost stock certificates. Everyone always loses those. Haven't issued those for a long time though. But collect all the assets and see what claims come in and determine if they're valid claims. And then you'll have to settle with all the creditors. That doesn't mean pay them in full. It's one of the things that I like to do with clients that hire us for probate. I enjoy negotiating with creditors, and we can often get very good results in reducing those debts. After all the debts are paid, then you'll send an accounting to all the beneficiaries, let them know what the proposed distribution is, show them how much the personal representative is charging for their fee, as well as disclose the total amount of legal fees and all the other expenses of the estate. After that's approved, then a final distribution can be made to all the beneficiaries of the estate, and then the probate can be closed. So how long does that take? Um, Two major steps in this process, I would say. The first step is getting the personal representative approved. So that takes about 4 to 6 weeks. At least that's what it takes us in Arizona, and that's 2 to 3 weeks of our time to prepare the paperwork. And then once we get it signed, that's another 2 to 3 weeks for the court to approve that paperwork. So that's the first step. Once the personal representative has the authority, then we start the creditor period, which takes 4 months. And during that time, if the personal representative is able to collect everything during that 4 months, the probate can be wrapped up right after the creditor period's over. So the fastest a probate can go in Arizona is about 5 to 6 months. Usually it takes about 9 to 12 months is probably the average. And depending on what the assets are, if it takes a while to sell certain assets, like if you're waiting for a house or a lot to sell, um, then it can take longer to settle an estate and to close out the probate. So what are you going to do? What are the steps? You're going to look for the assets, see what's out there, find the players, and figure out what controls the assets. So is there a beneficiary designation on the IRA or life insurance or even bank accounts? Bank accounts, they call them POD sometimes, or TOD, payable on death, transfer on death. Are things titled in the name of the deceased, or are they titled in the name of a trust? So figure out what controls. Now, for things in the name of the deceased, that's where their will is going to be controlling if they have one. And then if there's no will, we're going to look at the laws of intestacy to determine the beneficiaries and who has priority to serve as a personal representative. All right, so if you are the fiduciary, if you're that green hat wearing guy responsible for others, you need to safeguard the assets, get appointed, get the formal authority to act. So through probate, you have to become appointed the personal representative, or if you're the trustee, you have to prove that you're the trustee. And then you're gonna follow the instructions. You'll follow the will if there is one. If there's no will, then, you'll distribute according to, the laws of intestacy, and then you'll follow that fiduciary duty. I recommend legal counsel. I'm a little biased as an attorney, and also I see all the things that do go wrong. That's when I get contacted. So I always recommend that you hire an attorney to help you with that fiduciary duty. Make sure you don't get sued by your siblings. The trust may require you, if there is a trust, it may require to set up sub-trust for beneficiaries that are underage, or maybe dynasty trust. Now, if you're a beneficiary, if you're not the one in charge, if you're a beneficiary, what you should be doing is ask for a copy of the legal documents, ask for an accounting, and then if you get those things, if you get a copy of the legal documents and they're giving you notice of the assets in the estate and let you know what's going on, then be patient. It does take time for all of these things. Turnaround time for attorneys, it's typical that it takes them 2 to 3 weeks to do anything. That's our standard turnaround time, and I know it's pretty common in law firms. So, and be mindful of the overall process of the probate. So it's gonna take, probably about a year. Um, but if it's taking longer than that and you're not getting information, they're not being forthcoming about the assets in the trust or the estate, that's when it's recommended to contact an attorney to see what's going on. All right, there's my contact information again. Hope you found this helpful. If you have any questions about probate or setting up your own estate plan, you can reach out to us. If you haven't created your will yet, there's a free link below. There's a link where you can create your own last will and testament for free. So no excuses. Want to make sure everyone has a last will and testament. So if you haven't done that, look at that link below. And it only takes about 10 minutes or so, and you can have a valid last will and testament to protect your family. Thank you, everyone.